The aim of the forum has always been to encourage effective cooperation and dialogue between judicial and legal professionals by facilitating discussions about shared challenges on the rule of law, protection of human rights, judicial reform, and in particular to share best practice in overcoming such challenges. As you'll know, for the past 2 years, as a result of COVID pandemic, we have been forced to modify the format of the forum, and we introduced a hybrid model with many participants joining us online. We are really happy that the forum has become such an established part of the judicial calendar in the region that this new format did not dull the enthusiasm of participants to contribute to the forum. However, it is my view that the real heart of the success of this event lies in engaging and constructive discussions which take place both at the panels and at the breaks, and many follow-up initiatives were born out of those discussions. So it is my great pleasure for us all to be back together in Tirana and to welcome in particular judges and former judges of the European Court. I'm also grateful to judges of the European Court who are not able to join us in person, but who will present to the conference via video link. It is true that whilst the pandemic fortified our commitment to be together, it also forced us to learn and adapt, meaning that we can now more readily facilitate remote participation and maximize expert input in the event. As we emerge from this exceptional period in our history, it is tempting to seek to simply return to the business as usual, to move on, to look forward, rather than looking back on what was for many incredibly difficult time. But it is exactly at this point, as we begin to recover, that it is perhaps most useful to reflect on the lessons learned, on the new practices and procedures which were adopted and which we might want to preserve, to analyze mistakes made, and to think about how we could have or would in future respond differently and more effectively. With this in mind, the focus of this year's forum is on protection of human rights in times of emergency. Just over 2 years ago, in October 2020, we convened a forum focusing on COVID and its impact on human rights. At the time, there was very limited case law pertaining to the kind of public health emergency which we faced in terms of scale, of number of states affected, and range of convention rights impacted. 2 years on, we have an opportunity to reflect on key legal developments and relevant European and domestic jurisprudence since the start of the pandemic. It also provides the opportunity to launch our updated guide on human rights in times of emergencies, which incorporates these most recent developments. When states are required to respond quickly to a serious and complex emergency, rigorous parliamentary scrutiny of emergency measures and their compatibility with human rights might not always be possible, as we've learned. In this context, effective and independent judicial scrutiny of executive measures become yet more essential to hold the governments to account and to protect fundamental rights and the rule of law. Exceptional measures which are taken to protect the life and health of a nation must still comply with the paramount convention principles of lawfulness and proportionality. And courts, as well as independent ombudspersons, have a vital role to play to monitor compliance with these principles. This forum will therefore also draw on lessons of the pandemic to focus on the role of judiciary in scrutinizing emergency measures, including what exactly constitutes effective and independent judicial scrutiny during times of emergency and how courts might need to adapt to function in convention-compliant manner during times of emergency. As states across Europe continue to face new challenges, such as the war in Ukraine or the ongoing climate and energy crisis, it is essential to future-proof the protection of human rights in face of turbulent and unpredictable times we live in. We also recognize that times of emergency can often force creativity, prompting states to adapt and to implement more quickly and effectively. And the forum will therefore also provide opportunity to consider how the way in which the courts operated evolved during the pandemic, and this includes European Court, and identify changes which were introduced during this time that might be useful to safeguard and build on going forward. For example, sustaining the possibility to use remote hearings if this would serve to increase judicial efficiency and access to courts. Finally, it's now left for me to thank all of those who have made this forum possible. I extend my thanks to judges and former judges of the European Court who have been closely involved in the planning of this event, the UK Government of Sweden, and Konrad Adenauer Foundation, who recognized the importance of our work and gave us means to carry it out, our hosts in Tirana, who have been so helpful and welcoming, in particular our partners at the Civil Rights Defenders for close to a decade of extremely good cooperation on this joint journey. And lastly, I'd like to thank my team at the Air Center for their hard work over the past few months. And by way of closing remarks, I would like to thank all of you for participating here, for the enthusiasm you've shown in joining this event, and to thank you in advance for what I'm sure will be your invaluable contributions. I wish you 2 very successful days, and I look forward to discussions ahead of us. Thank you.